Hi guys, and welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we have our final installment on the law of contracts, and we continue with the defective contracts. Specifically, we talk about the void contracts, okay? So if you like my videos and you want to see more, please hit the subscribe button. Please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law, okay? So, the law talks about void and inexistent contracts. While technically, void contracts are different from inexistent contracts, we use void and inexistent interchangeably. And we can refer to these kinds of contracts simply as void contracts. However, for the sake of learning, let's just differentiate void from inexistent contracts, okay? Void contracts are those which, because of their defects, produce no effect at all, okay? It is as if they are inexistent from the beginning. While inexistent contracts lack one, some, or all of the essential elements necessary for validity, or they do not comply with the formalities required by law, such as when the law requires a certain form for a contract to be valid, to be enforceable, or for public convenience. Now, for a deeper discussion on formalities, please refer to my video on the forms of contracts, link in description below. Okay? Now, let's go to the characteristics of void contracts. Okay? First, void contracts produce no effect, okay, whatsoever. They have no force and effect, and while a party does not need to file an action in court to declare that a contract is void, it is of course better if he does so, no? For the sake of peace of mind or to avoid the parties taking the law into their own hands, it is of course better to file an action in court to declare the contract void. Second characteristic, no? Void contracts can never be ratified because void contracts are contracts which as if they never existed, okay? So if they never existed, there is nothing to ratify. For a deeper discussion on ratification, please refer to my video on voidable contracts, link in description below, okay? Now, third characteristic. Now, a party may have a right to bring the defense of illegality of the contract. And the right to bring this defense cannot be waived. Okay, let's make it clear. For instance, a party brings an action before the court to enforce a contract which is actually void. Now, the other party, may raise the defense that no, I should not be held liable under that contract because that contract is actually void. This party cannot be deemed to have waived this right, of course, because he raised it. But even if he does not raise it, the right to raise the defense of illegality of a contract cannot be waived. Okay? Fourth characteristic of voidable contracts. An action or defense for the declaration of illegality of a contract does not prescribe. Okay? If you remember, by prescription or through the passage of time, rights may either be gained or lost. So even when enforcing a contract, there is a time period within which you can only bring that, It can expire, and if it's past the deadline, it has prescribed and can no longer be enforced. However, in case of a void contract, the action to declare that it is void or inexistent does not prescribe. Okay? Wala po yung time limit. Okay? Now we go to the fifth characteristic of void contracts. Now, the defense of illegality of a void contract is not available to third persons outside the contract whose interests are not directly affected by the contract. Okay? If you remember my video on the general principles of contracts only take effect between the parties to the contract or their heirs, assigns, or successors in interest. Okay? In other words, third parties who are not part of the contract are not affected thereby, unless, of course, it involves a real right which affects the whole world. Or, in case of contracts which are entered into to defraud creditors. Okay? And finally, the sixth characteristic of void contracts are that void contracts cannot give rise to valid contracts. Okay? In other words, in case of novation, there can be no novation if there is no valid contract in the first place. Okay? In other words, there is nothing to novate. Okay? Void contracts cannot give rise to valid contracts. The remedy is easy. Simply make a new valid contract. Okay? Now we can start with the enumeration of the void and the inexistent contracts. Okay? First, we have those contracts whose cause, object, or purpose is contrary to law, morals, good customs, public policy, or public order. Okay? If you remember also my discussion on the general principles of contracts under the essential characteristic of autonomy or freedom to contract, parties are free to enter into whatever terms or conditions they may so desire, no, into a contract, as long as the same is not contrary to law, morals, public policy, order, or customs, no? Now, in case the terms or stipulations or conditions are contrary to law, morals, customs, public policy, or public order, then that contract will be void. Okay? So now, here are the rules in case of these kinds of contracts. Okay? First, what if both parties to the contract are equally guilty or in pari delicto? Okay, we will be using in pari delicto, the Latin words for a case where both parties are equally guilty. Okay, so in case of in pari delicto, the parties shall have no action against each other. They cannot file a case against each other to either enforce the contract or declare it void. Now, both of the parties who are in pari delicto shall be prosecuted in case the act is a criminal offense, no? And finally, the object or price of the contract shall be confiscated in favor of the government as the effects or instruments of the crime. Okay? This is the case where both parties are equally guilty in case the cause or object is illegal and the act constitutes a criminal offense. Now, the exception in that case where the parties are in pari delicto is if one of the parties is incapable of giving consent, such as in the case of a minor or an insane person, no? In this case, the court may allow the incapacitated party to recover the money or the property he may have given if the interests of justice so demand. Okay? Now, it's not necessary in that case that the illegal purpose was achieved or that there be damage to third persons. Okay? In the case of the incapacitated person. Okay, second rule, no? What if earlier both parties are equally guilty? Now, let's talk about the situation, no, where only one of the parties is guilty or both parties are not equally guilty. There is one who is less guilty. Okay? Again, the situation contemplated is where the cause or object is illegal and the act constitutes a criminal offense. If only one of the parties is guilty, then the innocent party may claim what he has given by virtue of the contract, and he is not bound or cannot be compelled to perform his part of the obligation. Okay? Okay, now let's go to the second scenario. What if the cause of the contract is unlawful or illegal, but it's not a criminal offense now? Okay? First, if the parties are in pari delicto or both equally guilty, then of course, neither may recover and neither may demand performance. Okay? However, if only one is guilty, the guilty party of course cannot recover and he loses the thing or money given. He also cannot ask for performance from the innocent party. Okay? However, the innocent party may demand return of whatever he has given and cannot be compelled to perform his part of the obligation. Okay? Third rule under these kinds of contracts, no? If money is paid or property is delivered for an illegal purpose, the other party may repudiate or refuse to fulfill or perform his part of the obligation. He may repudiate the contract before the illegal purpose is accomplished or before damage is caused to third persons. And in this case of repudiation, the court may allow the party who repudiated the contract to recover the money or property given if public interest is subserved. Okay? Fourth rule, in case of contracts whose cause, object, or purpose is contrary to law, etc. No? Fourth rule, if the agreement is not illegal but is merely prohibited, no? And the prohibition is for the protection of the plaintiff or the injured party who is bringing the case, no? Then the injured party may recover if public policy is enhanced. Okay? Fifth rule, no? Let's say there's a law, an executive order, which sets the price for certain goods, no? Meaning there is a ceiling for a certain price. This is relevant especially in case of overpricing the sale of goods, no? So in case there is a law that sets a certain price for goods, the party who has paid an amount in excess of the price set by law may recover the excess paid. Okay? Sixth rule, no? In case a contract is entered into where the hours of work in employment are more than what the law says, and in our case, the Philippines, the hours of work are only 8 hours, no? In case the contract says an employee has to work more than the amount set by law, then he is entitled to additional compensation. This is known as overtime pay. If you want to learn more about the basic rights of a regular employee, please watch my video on that subject, link in the description below. Okay? Seventh rule. If a contract is entered into for employment, no, that gives a wage lower than the minimum wage set by law, then the employee is entitled to recover the deficiency. Okay? Final rule. Okay? If a contract is divisible, meaning its cost, okay? There is a difference between divisibility of the cost and divisibility in performance, okay? In case the contract or the cost of the contract is divisible and you can separate the illegal terms from the illegal terms, then the legal terms may be enforced. Okay, what's an example? First, I'll give you an example where the cost of the contract is indivisible. You cannot divide it, no? For instance, if a car and shabu are sold for 200,000 pesos, then that is indivisible because you don't know how much of the 200,000 pertains to the car and how much pertains to the shabu, a prohibited drug. Okay? So, in that case, you cannot separate the illegal terms from the legal terms and that contract is totally void. But, if the terms of the contract state that the car shall be sold for 150,000 and the shabu for 50,000, then the contract is divisible and you may enforce the terms upon the car only. And the stipulations as to the shabu shall be void because it is contrary to law, okay? Being a prohibited drug, okay? Now, those are the rules in case of a void contract, which is void because the cause, object, purpose is contrary to law, good morals, good customs, public policy, or public order. Okay? Now we can go to the second kind of void contracts. The second kind of void contracts are those which are absolutely simulated or fictitious. So what is a simulation of contract, no? Simulation is an act of deliberately deceiving others, okay, by feigning or pretending that this is their agreement when in fact the agreement does not exist, or the real agreement is concealed. Okay, that's simulation of contract. And under simulation of contract, we have two kinds, no? We have the absolute and the relative simulation of contract. Only one of these two is void, okay? Let's talk about the absolute simulation of contract. Under the absolute simulation of contract, the contract does not really exist, okay? Because the parties do not intend to be bound under the contract at all. And these are the contracts that are void, okay? Because there's really no contract at all, no? And the parties do not intend to be bound. What's an example, no? Let's say a person sells a piece of land to another for no consideration or no price, no? But they have a deed of sale. They pretend that there is a sale, when actually this person is just holding that land for this person. And why did this person enter into that sale with the other? Because this person wanted to evade the fulfillment of his obligation to one of his creditors. Okay? So in that case, this person here is just pretending to have an actual contract when none exists at all. And that kind of contract is void, obviously, because there is nothing, no? There is no such sale. Especially since there is no price or consideration or cost involved. Okay? So let's talk about a relative simulation. Relative simulation happens when a contract is entered into which is different from the true or real agreement of the parties. Okay? An example is when the parties pretended to enter into a deed of sale, but in reality, it is donation, no? That example was more pertinent prior to the train law when the tax rates of transfers of real property were different from tax rates on donation, okay? The rules may be different now under the train law, okay? But in any case, the parties may have entered into a contract of sale ostensibly, no, meaning on the piece of paper, but in reality, they had intended a donation of the property. Now, the rule in case of relative simulation is that the parties shall be bound by the real agreement provided, okay, provided it does not, one, it does not prejudice third persons, and two, the purpose is not contrary to law, morals, good customs, public policy, or public order. Okay? Relatively simulated contracts are valid, but the parties will be held to the real agreement, okay, what they actually intended, and provided that it does not prejudice third persons, and provided that it is not contrary to law, morals, etc. Okay? Third kind of void contract. We have one where the cause or object did not exist at the time of perfection of the contract. Okay? So, this does not apply to future things which may legally be the object of a contract. An example is future crops. What is contemplated here under this kind of contracts are those that would be actually physically or legally impossible of performance, or those which cannot have come into existence at the time of perfection of the contract. Okay? So for a deeper discussion on the existence of objects at the time of perfection, please refer to my video on the essential elements of contracts. Link in the description below. Okay? Next kind of void contracts. No, we have objects which are outside the commerce of men. And what are these things that are outside the commerce of men? Things that are of public ownership, like sidewalks, public parks, like that. So you cannot enter into a contract purporting to sell to another a certain sidewalk. You cannot do that because you do not own that sidewalk. Okay? Or those which are common to everyone, such as rain or sunshine or air. Okay? You cannot tell a person, I am selling to you all the rain that will happen on this certain day. Okay? You cannot do that. Okay? So, we can now move on to the next kind of void contracts. Okay? Those which contemplate impossible services. No? Such as to get soil from Pluto or whatever, no? For again, for deeper discussion on impossibility, please refer to my previous videos. Okay? And the next kind of void contracts are those where the intention of the parties relative to the object of the contract cannot be ascertained. Meaning, you do not know. You cannot find out from the intentions of the parties or their contemporaneous or subsequent acts what they had intended to be the object of their contract. Okay? One example is when X tells Y he will sell him a parcel of land. But X has many parcels of land and you cannot tell which of those lands he is selling. So in that case, you cannot decipher the intent of the parties and therefore the contract shall be void. Finally, the last kind of void contract are those which are expressly prohibited or declared by law to be void. Okay, I'll just give you some examples, but these have either been discussed previously or will be discussed in the future. Okay, first, contract over future inheritance, no, is void. Why? Because it is not yet in existence. It is a mere expectancy. Again, inheritance is not what you have received from someone who has died. Inheritance is the mass of property, rights, and obligations which a person leaves behind after death. No? So you cannot have contract over future inheritance because you are stipulating upon the death of the person who has not yet died. Okay? Next example of contract prohibited by law, no? Sales between husband and wife, except if they have agreed upon a separation of property or a judicial separation of property exists, no? Next, donations between husband and wife, except moderate gifts on the time of celebration, etc., no? Next kind, no? Sales by certain people because of their position or their relation to the property in their control. No, these are the special or specific incapacities under the law on sales, such as sale, acquisition of a property by the guardian of the property of his ward, agents of the property of their principal, judges, lawyers of the property of things under litigation, or public officers over the property which they administer. Okay, I'll be discussing that on the law on sales. Okay, and one more example. Let's say there is a testamentary disposition, meaning person through his will is giving property to a person who is disqualified to receive it under the law. Okay, to learn more about wills and succession or inheritance law, please refer to my video on the matter, link in the description below. Okay, so that's it for void contracts. No, I hope you have picked up a thing or two, and I hope to see you next time. Okay, see you later. Bye.